My name is Professor Peter Whelan. I'm a Professor of Law at the University of Leeds in the United Kingdom. I'm going to talk today about the use of criminal sanctions for cartel activity. And by criminal sanctions, I mean the use of imprisonment, i.e. custodial sentencing, against individuals who have been convicted of cartel activity. Now, this is a difficult area of law enforcement, I would argue. It certainly presents difficult challenges that need to be met for those who advocate in favour of introducing and maintaining a successful policy of cartel criminalisation. I recently wrote a book on this topic, and that book covers my thesis, which is that there are various theoretical, legal and practical challenges that exist and interrelate in this particular debate. And those challenges need to be met if the individuals or entities arguing in favour of criminal sanctions are to actually successfully do so. Now, this debate has a number of different issues. For example, we could talk about the necessity of introducing criminal cartel sanctions. We could also talk about whether they're appropriate given their inherent nature. And also we could talk about the potential here for differences in social attitudes regarding cartel activity and whether those differences in social attitudes have potential to undermine a policy of cartel criminalisation in practice. So I think it's important to consider moral norms, social norms, those rules of behaviour that generally affect our own behaviour in society. And those norms are relevant, I would argue, in the context of cartel criminalisation. Often the debate focuses on the issue of deterrence, and I'll get to that in a second. And in that particular context, the argument is that criminal sanctions help to deter cartel activity, and therefore we should rely upon such sanctions if we wish to deter such objectionable behaviour. That said, very few individuals have examined the morality, let's say, of cartel activity in this particular debate. So that's something that I have contributed to myself, and it's something I'd like to underline with this particular presentation. We could also, of course, talk about the difficulties that are present when we come to having to design the criminal cartel offence in such a way that it is effective in achieving its underlying justificatory objectives, but also that it adheres to legal norms and also works in practice. So there are issues of design and implementation that need to be considered. They can be quite difficult. And also, of course, we need to think about human rights, because we'll be moving from, let's say, an administrative regime to a criminal one, so one would expect to see some degree of strengthening of those particular rights. What difficulty does that actually present, that process present, in terms of a criminalisation policy? That's a particular question that needs to be addressed. And also we can talk about political and public support and publicity for the regime. Now, let's just go back to deterrence for a second. This seems to me to be the primary justification for criminal cartel sanctions. So the idea here is that criminal sanctions are argued to be the most meaningful deterrent to antitrust violations. That's to quote Lyman from the 1970s. They also, according to Bauer, send a message to other executives about the risks and penalties for this kind of behaviour. So executives tend to listen, so the argument runs, when criminal sanctions are at issue and are being imposed for price fixing, compared to situations where we have administrative fines, let's say, being imposed on individuals or just simply on companies. Now, the policymakers want to stop cartel activity from occurring in future. That's the idea of deterrence. So we look forward and we try to ensure that the activity does not occur again. And the main approach to justifying criminal sanctions in this particular context is to make the assumption that cartelists are rational, self-interested beings. And with that assumption, then we can work out, using the available cartel statistics, what sort of fine should be imposed upon cartelists in order to deter them. Now let's assume that we are imposing fines simply upon companies. Well, if we use the available statistics from cartels, we can actually estimate the fine to be in the region of at least 150% of the annual turnover in the cartelized market for that particular firm. Now, that's a figure that's put forward by Wouter Wills in particular, but others have constructed similar figures, even some going as high as 200%. And the idea here is that that fine is so large that it cannot be imposed in practice. Now, sometimes there will be a legal limit on the fine that can be imposed upon a company. So, for example, in the EU, we have a 10% cap that applies under Regulation 1/2003. That cap, of course, applies to the global turnover of the undertaking. And so we need to think about that, but the cap could be removed if we wanted to impose this sort of sanction of 150% of annual turnover. However, the point is that if we impose such a fine, we're going to have significant problems, significant negative externalities. For example, the potential liquidation of the company and the social losses that will result from that. We might also have the exit of the company, and therefore we have an increased concentration occurring in the market, a market that has already been subject to cartel activity. So the point here is that we have an option. We can do nothing and we can try to simply impose a fine on the company and hope that it's a deterrent, or we can try to fill the deterrence gap that has been identified by relying upon individual sanctions. Now, the point here is that we don't simply want to turn to individual fines to plug that gap, because the individual fines could be paid by the undertakings, by the firms. They would certainly have the incentive, according to the theory, to indemnify the individuals who suffer an individual personal fine, whether it be in a criminal context or an administrative one. So what we need to do then, so the argument runs, is to turn to sanctions that are non-indemnifiable. And that's where custodial sentences come in. The idea being that individuals will not risk going to prison in order to make profit for their firms. Okay, I'm not saying I agree necessarily with all the steps in that argument. There are certain assumptions that are made, and those assumptions can certainly be questioned. But the point is that is the argument that is generally put forward. Now, of course, there are other arguments to do with certain advantages to criminal sanctions, such as the available powers of the authorities in that context that may not exist in an administrative setting. There may also be a positive impact upon administrative leniency programs, provided that there is indeed an individual criminal immunity policy that is operated by the jurisdiction. So now I want to turn to some of the problematic issues with this particular mechanism of enforcing competition law. Now, one issue that needs to be addressed here is the idea of efficiency. Is cartel criminalisation an efficient way of dealing with the problem? It may well be an effective way of dealing with the problem, but it doesn't mean that it's efficient, because there will be many costs involved in enforcing competition law with criminal sanctions. So it may well be the case that criminal sanctions will stop individuals engaging in cartel activity, but the cost of ensuring that's the case may be so much that in fact it's not worth the effort to actually criminalise at all. So that's the first point. The second point, which I think needs to be addressed, is the idea of morality. So as I mentioned earlier, this deterrence argument does not really consider the issue of morality. And I think that is a problem. I think in this particular debate, we need to be satisfied that the criminalised cartel activity displays a degree of moral wrongfulness such that we would be happy as citizens to see this sort of activity leading to the imprisonment of individuals who are usually productive members of society. So I just want to pick up on the morality issue, because this is a short video and I can't address all of the issues that I would like to address, but I want to address this one. So the idea here is that by imposing criminal sanctions on individuals where we ignore morality, we might be treating those individuals in an unfair manner. So we can look to the words of Sayre from the 1930s about this idea of strict liability criminal offences, where he mentioned that when the law begins to permit convictions for serious offences of men who are morally innocent and free from fault, who may even be respectful and useful members of the community, its restraining power becomes undermined. Now, I think that's a strong point, and I think it's one that needs to be addressed here when we're looking at the issue of criminal sanctions. Now, of course, we can use the criminal law to educate people about morality, but there are limits to that particular function of the criminal law. Certainly, if we can demonstrate that there is already a moral norm against cartel activity in society, then it becomes easier to enforce this particular prohibition. It certainly becomes cheaper, in that we may have internalization of the norm by business people and self-enforcement if they understand how it is that cartel activity violates their own social norms. Now, we could look at a number of different norms in this context, such as stealing, deception, promise breaking, and the work of Stuart Green in particular is very useful in this context to address that particular issue. I just want to finish this small presentation with a little insight into how we might use one of those particular norms, the norm against stealing. So what is stealing? Well, stealing could be understood as something that involves the following elements: an intentional and fundamental violation of another's rights of ownership in something that is capable of being bought or sold. Well, there's something that is capable of being bought or sold is fairly easy to understand. It's the overcharge, that higher price for the good that results from cartel activity. The intentional and fundamental violation is also relatively easy to understand in this context. Here we have the seller keeping the overcharge and spending it as she wishes. So the real question then to line up criminalized cartel activity with stealing is whether consumers have the right of ownership to that particular overcharge. Now, this is a very difficult issue to resolve. How indeed would we establish that consumers have rights of ownership in the overcharge? We could argue that such a right exists by virtue of our acceptance of the free market. That seems a little bit of a difficult argument to make, in my view. It might be easier to use your civil competition law for a number of years to create this particular right in people's minds about the overcharge and the fact that it should actually not be paid out by consumers. Now, in doing that, we would of course need to rely upon a consumer welfare standard of competition law. But there are still problems here, because if we think about it, we can see that the prohibition of cartel activity in various jurisdictions across the world does not necessarily require that the agreement in issue be implemented. So if we have, for it to be unlawful, so if we have no implementation of the cartel agreement, we don't really have an intentional and fundamental violation, and therefore we don't have stealing. We may have an attempted theft, but no stealing. So this is just one issue I wanted to raise, the idea that we need to link cartel activity to some form of immoral behaviour, wrongfulness, if we are indeed to criminalise it.